members, I have received any other apologies, but I will at this time allow members to introduce themselves for the record, but also if you are here as an alternate, please indicate who you are representing. Thank you so much. Over to the members.
Good evening, Chair. This is Killian Postman. I'm here representing myself.
Thank you, sir.
Evening, Chair. Ayanda Barnes.
Ron, quickly come here. Did you know of another meeting now?
Good evening, Chair. Can you hear me, Chair? Yes, it's member Mesuli Kama. Chair, I'm an alternate to in the cultural affairs part of the committee. But now I don't know how to respond to the question as to who am I representing, as I usually attend the committees even when member Pants is present. Unless for this one, we only require a permanent member of the committee.
Thank you. That's duly noted if you were representing Member Barnes, for example, but thank you for your attendance as always. I also note that Member Peter Marais is present. With us, we have our procedural officer, Mr. Wasim Matthew. Welcome you. Thank you for making the time to meet in this way for this briefing. It has been key for us to get this over and done with, but also to understand that we have received dates and times from the NCOP. Like I indicated earlier on, Honorable Sileku will be joining us as the permanent delegate. Regarding the rules of engagement for today, I would encourage all members to mute themselves at the beginning of the meeting to avoid any background noises. Also, if you want to flag the attention of the chairperson, you may raise the hand function within MS Teams. I will also encourage that all videos and audio must be switched off to improve the quality of the connection. However, if a member or an official is speaking, they may put on their mic and their video. Participants will then have to switch off their mics once they have finished speaking. The reason for today is that we are receiving a briefing from the Department of Justice on the recognition of Customary Marriages Amendment Bill. We have department officials with us. I'll now allow them to introduce themselves. Over to the department.
Oh, sorry, Chair.
Who did I hear? Honorable Kama?
Honorable Sileku.
Are you here, sir? Thank you so much. I note you. Thank you for being here. Honorable Barnes, your hand is up.
Yes, Chair, my hand is up. Can I proceed?
Yes, you may.
Okay, Chair, I just need you to clarify me on something here. This meeting that we are attending, is it for the portfolio committee? My reason for asking that is the way you have given your introduction as if it's specified to a particular kind of agenda. What I want to know, is it for the standing committee or what's really happening? Can you just give me clarity on that? Thank you, Chair.
Thank you so much. Clarity in terms of the bill that has been referred to the Provincial Parliament of the Western Cape. We received dates via the NCOP. We have the permanent delegate with us. This is a standing committee for community safety, cultural affairs and sport, where we are being briefed on the bill, where questions and input will receive later on and resolutions will be taken. Very similar to our 1-2 days ago. I trust you find that in order.
Cover, Chair. I just needed clarity for the rest of the committee members. Thank you.
Thank you so much. I firmly believe after a very long day, I probably need clarity myself. But thank you once again for being here. I'll now hand over to the department.
Same is Teresa Ross, from the Department of Justice in the unit dealing with legislation development. Chair?
Yes, ma'am.
I realized a colleague of mine missed the meeting because earlier he's also in a meeting. He's also a state law advisor in the legislation development unit. Thank you.
Thank you so much. I'll also allow for introduction.
Thank you very much, Lorraine Buerta. My apologies, Chair, for joining late. I had some struggle. Thanks.
No problem. Thank you, Member Botha, and to all the members present. I'll now hand over to our permanent delegate for any comment or remarks at the beginning. Thereafter, we will go straight over to the department for the briefing. Over to Honorable Seleku.
Excuse the light, Chair. Thank you very much. No, Chair. Firstly, I'd like to greet all the members and official from the department and for an official from the... What the bill seeks to do is to give effect to two constitutional judgments. And these two constitutional judgments found that Section 7.1 of the Recognition of Customary Marriages Act 1998 to be inconsistent with the Constitution and invalid in that it limits the rights of human dignity, especially when it comes to females. So what it actually says that if you are in a polygamous marriage, you would be succumb to your husband, and you don't have a say. You just there. And what is important about this is just to make sure that there is no discrimination when people are in polygamous marriages, especially in customary marriages, are involved. And also, what also is important about this is that there has been questions about this particular section, if it affects like Hindu or Islamic marriages. And what was shared with us as the select committee was that, unfortunately, this one deals specifically with indigenous customary marriages, and the Department of Home Affairs is actually tasked to look at all marriages, within the country, and those amendments will be put in front of the National Assembly for consideration, and then automatically it will come to the select committee. And in terms of the technicality of this particular amendment and remedy, I would allow the department to give you some background and how it is going to change this particular 7.1. Thank you very much, Chair. That's all from my side.
Thank you so much to our permanent delegate, Honorable Seleku. To Ms. Ross, if I can just get an indication if you require the procedural officer to share the screen or if you will do so.
Chair, can I please request that I'm not able to do it from my side?
Mr. Wasim Matthews will be sharing the presentation, but directly over to you now, Ms. Ross. Thank you.
Thank you, Chair. Chair, thank you and for the opportunity, and thanks to Honorable Seleku for that background. It is spot on. Chair, as Honorable Seleku has indicated, the objective of this bill is to amend the Recognition of Customary Marriages Act of 1998 in order to give effect constitutional court in two cases, the one being of Ramuhovi and then the other one of Gumede. Chair, this is I would say straightforward bill in the sense that it only aims to give effect to the decision and judgment of the Constitutional Court in those two cases I've mentioned. And as a way of background, in slide 1, I've already indicated that the bill aims to amend the Recognition of Customary Marriages Act, but it does so by regulating further regulating, because proprietary consequences of a customary marriage are already regulated in the Recognition of Customary Marriages Act. So this bill further regulates those proprietary or ownership rights in property, ownership rights in a customary marriage. The bill aims to bring this act, or specifically Section 7, Subsection 1, and Section 7, Subsection Constitutional Court judgments. And moving on to slide 3, in slide 2, what is okay, slide 3, okay, slide 3, because I've already alluded to the Ramuhobi judgment, and in the Ramuhobi judgment, what happened in this case is that the Limpopo High Court declared Section 7, Subsection 1 of the Recognition of Customary Marriages Act to be inconsistent with the Constitution, because it discriminates unfairly against women in polygamous marriages, which were entered into before the Recognition of Customary Marriages Act came into operation, on the basis of gender, that is, on the basis of them being women. It discriminates against them on the basis of race, they being African women, and it discriminates against them on the basis of ethnic and social origin. Moving on to slide 4, this slide deals with what the Section 7, Subsection 1 currently, or before the decision of the court, or as it stands in the statute book, how it reads. And this section provides that the proprietary consequences of a customary marriage is entered into before the commencement of the Recognition of Customary Marriages Act continue to be regulated by customary law. Chair, we are aware of the concerns that are always raised about how, customary law principles and their application to women, whether in society in general or in terms of marriage, how they discriminate against women. Now, the concern is, if Section 7, Subsection 1 says customary law continues to regulate proprietary consequences in property particularly, if it says that, then it means women in customary marriages have no right of ownership of property, and that the ownership and control of property in a marriage is the sole purview of the husband and or wives in the case where there is more than one a wife in a customary marriage. Now, the Constitutional Court in the Ramohovi decision found this to be the case, specifically with vendor customary law. But that it cannot be said that that is not happening in other communities or cultural groups in the country. Coming to slide 5, the court declared this section to be wrong, to be discriminatory against women, and because they don't have the right to share in the proper marital property or the family property. And the court ruled that, in fact, women have the right to share equally the family property and then the right to management and control of such family property. The court was also of the view that the house property and the right to its management and control between the husband and the spouses should also be covered in this protection. Now, moving on to slide 6, which deals with amendments to clause 1 of the bill. Clause 1 of the bill aims to amend national leader in order to align that definition with the definition as contained in the Traditional Leadership and Governance Framework Act. Members would be aware that the reason for the inconsistency or there would be because the Recognition of Customary Marriages Act is a 1998 act, while the Traditional Leadership and Governance Framework Act is newer, a 1993 act. So it is necessary that there be consistency with regard to this definition in all the pieces of legislation as contained in the statute book. Now, moving on to slide 7, which deals with an amendment to section 7, subsection 1. This clause 2 is in fact the crux of the amendment. It amends subsection 1 of section 7, and the amendment provides that proprietary consequences of a polygamous customary commencement of the Recognition of Customary Marriages Act are that the joint and equal ownership and other rights of management and control over the marital property. Secondly, clause 2 provides further that the rights of all house property by the husband, or rather referred to or customarily referred to as houses, meaning that each and the spouses or wife can be, it's usually referred to as the first house, second house, third house, like that. And each and every house, there would be like a, and the bill provides that the property relating to that must be jointly controlled by the husband and the wife in each house jointly and in the best interest of the family unit constituted by the house concerned. The rights in respect of all family property must be exercised by the husband and all the wives jointly and in the best interest of the whole family as constituted by the respective houses. Coming to slide 7, slide is that each spouse in the marriage retains exclusive and unshared rights over their personal property, which means a wife in, say, the second house owns her personal effects personally and need not share that property with, say, a wife wants to share or that wife. Now, the bill, Chair, further provides that the family property, marital property, house property, and personal property have a meaning as ascribed to them in terms of customary law. What has been the development in regard to this provision? There were calls that the bill should define what house property, family property, and personal property. The made when the bill was in the portfolio committee. However, Chair, a view, and that is why it was left the way it is in the portfolio committee without having to define the definitions. Now, Chair, the effect of the amendment to subsection 1 is that the proprietary consequences of a polygamous customary marriage will no longer be dealt with in terms of customary law and will be dealt with in terms of other pieces of legislation that regulate proprietary consequences that are in the statute book. Like your Marital Property Act and Administration of Estates and other pieces of legislation that regulate ownership of property. Chair, on slide 9, slide 9 of the presentation further amends section 7, subsection 2, in line with the Gumede judgment. Currently, the Act or section 7, subsection 2 provides that monogamous customary marriages entered into after the recognition of Customary Marriages Act are marriages in community of property unless the parties themselves decide to opt out of the marriage in community of property and rather opt for a marriage out of community of property by excluding community of property by means of an antenuptial contract. Now, the bill amends this section 7, subsection 2 to provide that this default situation in terms of which marriages entered into after the commencement of the recognition of Customary Marriages Act will be marriages in community of property. The bill then changes that position by also making customary marriages entered into prior to the coming into operation of the recognition of customary marriages to be marriages in community of property, unless, of course, the parties decide to change their marriage regime. Chair, in respect of this clause 2 or amendment to section 7 subsection 2, members will notice that this is a 2009 judgment, and a question could be raised: why are these amendments only being effected now? The reason for that, Chair, is that this was an oversight that is, a very regrettable one for that matter, because, of competing priorities, and with 2009 having been an election year, and the need to, or rather, then this oversight resulted because of several factors. But in order to avoid that something like this does not happen again, the department has put in place mechanisms to address this situation, so that all the cases that come from the Constitutional Court, the High Court, or any court in the land are monitored, so that any remedial legislation that needs to be put in place does not slip through the cracks, like in this situation. Chair, the slide 11 deals with transitional provisions in the bill, and these transitional provisions are quite straightforward. The provision in the bill is that the bill will not affect the winding up of a deceased estate that has been finalized. It will not affect the transfer of marital property that has been finalized, and these exclusions that I've just mentioned will not affect also the transfer of property, of marital property, where at the time when the property was transferred, the person or the beneficiary of the transfer was well aware that the property was subject to a legal challenge. The last slide, Chair, just contains or deals with the conclusion. And in conclusion, I'd like to mention that the Ramuhovi judgment or the remedial legislation in Ramuhovi judgment, being this bill, should have been put in operation by 30th November 2019. Now, although the bill was introduced into Parliament in 2019, and 2019 having been an election year, Parliament did not have enough time to deal with all legislation. But in anticipation of that, the department made an application to the Constitutional Court for the extension of the deadline. But this application for extension was rejected by the Constitutional Court, and because the court held that because the interim order that the court made had since become final. So the Ramuhovi judgment is now law, but the legislature with the mandate that the Constitution bestows on it, needs to finalize the legislation, to finalize its mandate and its obligation of making law, so that it's the legislature that puts law in the statute book. That is the presentation, Chair. Thank you.
Thank you so much. Thank you so much, Ms. Ross. Members, we have received information that from the Chief Director, Cultural Affairs, Western Cape, there's no comment from them at this time. Members, I will now open up for a round of questions and input. If there's any member, if you can use the raise hand function on MS Teams. If you don't have it, you can just unmute yourself and indicate. I note Member Botha.
Thank you very much, Chair. I just want to understand through you, Chair, does this bill make provision for the LGBTQI plus communities?
Thank you so much, Member Botha. I see Member Barnes. Member Barnes. We'll come back to Member Barnes. I see Member Murray.
Thank you, Chair. Chair, I do believe that the bill, the principle of the bill, you cannot go against it because it speaks to equality. It speaks of women being uplifted at the same time and their rights protected. The problem I have is I am, in principle, I am against customary marriages where one man, he thinks he can marry as many wives as he likes, but he can't support these women, and then the women become a burden on the state with their families and children, and that is the start of poverty. So, okay, the bill itself, I got no problem with it. And if customary marriages is going to be the norm, the new norm, then I'll have to accept it. But but in principle, the whole thing about customary marriages, by me, it's not something I can go along. So I'll just stop there.
Thank you, Member Murray. Member Barnes. Member Barnes, your hand is still raised.
Chair?
Maybe to Ms. I hear you now. You may go.
Okay, Chair. Just a small one from my side. What I want to check, Chair, is on clause 1 of the bill. It says it amends in converted brackets traditional leader. What I would want to know is our parliament, obviously, we don't have a house of traditional leaders. Is there provision made for a parliament like ours? How do we translate that into, what options do we have? Yeah, that would be the question that I would want to know. And the last one would be on clarity on the Ramohobi judgment. It says that the Ramohobi judgment is the judgment that is standing. What I would want to know, if that is the judgment that is standing, what is our role within the bill if that is standing? Thank you, Chair.
Thank you so much. Any other member? Ms. Ross, we have 3 member questions so far, but I would want to add one question as per the presentation. You mentioned that each spouse retains exclusive rights over his or her personal property. I would want to get clarity or further information with regard to the fact that can we get a definition in terms of the terms that is mentioned on that slide, marital property, house property, and family property, because I foresee that without any clear definition within a marriage, a husband could potentially then define property as personal property. I'm not sure if I'm clear enough. It's like, do we have the definitions of the terms marital property, house property, and family property, in order to avoid any unforeseen circumstance where a husband could classify certain properties to fall under personal property, and to then to avoid then it being part of the joint full estate. If you can give some information on that. But over to you now, Ms. Ross.
Thank you, Chair, and thank you for the questions. The first question was, or is to the effect that does bill apply to, or does it take the LGBTI, and maybe I could even say Q, into consideration. Chair, the bill applies to everyone. And the good thing is that, you know, with the LGBTIQ being I would say, you know, foreign concept for lack of a better word in customary law. Now, the good thing is that the bill says proprietary consequences of a polygamous customary marriage will no longer be dealt with in terms of customary law. So in that regard, I would say that is a protection enough for the LGBTIQ community. The other thing, Chair, that I want to say is that although the amendments may be new, they are new because they are not in the statute book as yet, but they are. This is not a new piece of legislation. It's a bill amending an act that is in existence. That is the recognition of customary marriage. So all is going to happen is that these amendments in the bill will be merged into the recognition of customary marriages, which would then mean that it further regulates customary marriages. Whether they are members of the LGBTIQ who marry in terms of customary law, who marry in polygamously, then the bill will apply to them because it applies to everyone. To that, Chair, I would say, you know, it's a question of not application of the law, but rather the implementation of the law and the education, because if there is public education and everyone who applies the law knows that you cannot discriminate on the basis of one's gender, but the bill would be a law of general application. There's a question whether the bill that's what the traditional leader, the Western, okay, there's a question that because the Western Cape does not have traditional leaders. Okay, again, Chair, I would say because this is not a new law, it only affects corrections in the law that already is in existence. And the bill does not deal with marriage because customary marriages are already recognized in terms of the since 1998 when, or since 1998, and even since 8 November 2000, when the recognition of customary marriages took effect. And so the bill itself does not deal with marriages, but rather with the proprietary or ownership consequences thereof. And, you know, customary marriages themselves are not new. They have been there, recognized or not recognized, but they've been there. Whether they would be marriages, in customary law, there would be marriages, but in terms of other law, or say, you know, like in our civil law, were they marriages back then? Not, because, but from 1998, they started to become recognized marriages. The definition of the traditional leader, again, because the bill is not new, the relevance of a traditional leader in this bill is because traditional leaders have a role to play in the marriages, because some customary marriages need to be registered, and the traditional leaders have a role to play there. Those who are aware how customary marriages happen, like if you pay like lobola and then a letter of some sort has to be issued by a traditional leader, but traditional leaders have a role to play in the recognition of Customary Marriages Act. That is why it is necessary for the definition to be amended, to be put in line with what is contained in the Traditional Leadership and Framework and Governance Framework Act. But and they would apply. It doesn't mean that because it's in the bill or because it's in the act, it will apply to the Western Cape. No, it will apply to where traditional leaders exist. Chair, there was a question from you on what the definition, whether the bill could provide a definition or whether the bill provides a definition of what a personal property because of what the husband could do to take over the personal property of a wife. Personal property in this context, Chair, is personal effects of a particular individual. But coming to the definitions, I've indicated in my presentation that there were calls made that the bill should define what these terms mean. And because of the challenge of there being a lack of consistency across cultural groups and across cultures as to what family property or house property, or what house property means in, say, Xhosa culture, may not necessarily mean the same thing under the Zulu culture or the Sotho culture. Now, when we were consulting on the bill as a department, we raised this issue with the stakeholders, which included traditional leaders. And there was a lot of disagreements on what these terms mean. Hence, it was a view, and this approach was also taken when we were in the portfolio committee, that trying to define these terms where there is a lot of disagreement like this may, defining them without the benefit of a comprehensive consultation may lead to unintended consequences. And it was thought prudent that because the Department of Home Affairs is busy with this bigger project of reviewing and reforming a marriage regime in South Africa, and that process, because it's a very big project, it will be able to air this during the consultation process, will be where these issues will be able to be aired, so that common ground can be found on what these terms means. It may even happen that because of the diversity of cultures in South Africa, these terms mean different things to different cultures in South Africa. And because it was felt that having to take the bill back to go and consult comprehensively just to try and get a common meaning of these terms will delay the bill even further. I've mentioned, Chair, that these amendments, the Ramuhovi and the Gumede judgment should have been, or rather the Ramuhovi judgment should have been, the remedial legislation should have been put in place by November 2019. So already they are late, and trying to go into comprehensive consultation again to get common ground on this, the meaning of these terms, when we could not get that the first time when we consulted, will just delay the bill even further. Chair, I did not understand the Ramuhovi, whether the Ramuhovi judgment standing question clearly, but what I want to reiterate is that the court, because the court decided that the Section 7, Subsection 1 is unconstitutional and is discriminatory against women. And the court gave an order, meaning that the words that are found to be problematic in this provision in Section 7, Subsection 1 are then severed from the provision. And that is how, so this became the law the minute the Constitutional Court made its decision. It just needed to be put in the statute book. So that influenced the Constitutional Court decision to reject the application of the department when the department made an application to court to extend the deadline. The Constitutional Court said that will not help because that is already law. The order that the court made has become final. So whether an extension is granted or not granted, that is the law. It's only left for the legislature to fulfill its role of legislation making, to put this in the statute book. I think I've addressed all the questions, Chair. I thank you.
Thank you so much, Ms. Ross. Members, do you have any follow-up or any point of clarity based on the initial questions that were asked? I see Member Barnes.
Thank you, Chair. Chair, I would really want the meeting to be very patient with me, maybe because I'm not married, that's why I'm taking my time to really understand. On the presentation now, my response was that traditional leaders have a role to play. Now, my initial question was, understanding our provinces is different when it comes to traditional leadership. are we therefore catered for in this bill? But now, what I want to know actually is that I'm going back to the initial question. We also have customary laws here in the Western Cape. How are we going to deal with that? Or how does the bill, as is written already in clause 1 of the bill, how do we do, what's the option, what provision is made for a situation like this? Thank you, Chair.
Thank you, Member Barnes. Ms. Ross, I just have an additional follow-up query. In terms of your answer, I'm not sure if I heard correctly. You mentioned that the definition were not given because there might be some unintended consequences. Are you able to provide some examples of those unintended consequences? Because I can see how if those clauses are not defined and a husband is now married in a polygamous marriage, and he then categorizes property that should be under family, under marital or house, as personal property under his sole control. I'm not sure if that makes sense, just so that I can get it in my head on the definitions and why. Thank you so much. Over to you, ma'am.
Thank you, Chair. Chair, let me start with your question. An example of unintended consequences is exactly what you are alluding to now, of the husband categorizing personal property of the wife as family property, or giving it to any of the categories that are given in the will, categories of property. But Chair, what is important is that in terms of the bill, the husband has lost exclusive and sole control of the property under this bill. As you know, when this bill becomes law, or even currently, that is the case, because I've mentioned that the interim order of the court has taken effect, and this is law already, but it needs to be put in the statute book. So the husband no longer have the rights to do that. In the past, maybe yes, but not now after this Ramohovi judgment. Chair, maybe also to mention that the intention is not to discard a proposal and to define these terms, but rather to subject them to deeper and extensive consultation, because when we consulted, we could not we found that stakeholders themselves, persons who practice customary law, could not find common ground on the definitions of these terms. So a view has been held that before they can be put in a statute book, they need to be consulted on extensively, so that common ground is found, rather than for them to delay the bill, which is already late now. On the question of the role of traditional leaders, I understand the concern that there are no traditional leaders in the Eastern Cape, but customary law is practiced. But the role of the traditional leaders in the recognition of customary marriages is to further facilitate, you know, the validation of a customary marriage, be it by issuance of a letter to the effect that family A came to pay lobola for a daughter from family B, and that, or in the registration process of a customary marriage, because the parties to a customary marriage needs to be registered with Home Affairs, and although the registration thereof or the non-registration thereof does not invalidate the marriage, but the traditional leaders have a role. So I would say because there are no traditional leaders in the Western Cape, there's nothing that needs to be done in that respect. The problem could arise if a person in the Western Cape is married, getting married in terms of customary law in the Western Cape, and then they want a traditional leader to issue a letter or facilitate the registration process of the marriage. But a person like that does not need a traditional leader. You go to the traditional leader out of choice because some people subscribe to customary law, others don't. And even people who are in the urban areas where there are no traditional leaders, they still enter into customary marriages. But what they would do, they would go themselves without any traditional leader, without a letter or confirmation of anything from the traditional leader. They will go straight by themselves to Home Affairs to register the marriage. So whether the traditional leader was there or not, it's just for facilitation for those people who are in rural areas or in traditional communities or wherever, where they would want a traditional leader to issue them with this. But if there is not a traditional, you are not forced to do it. You go to Home Affairs to go and register your customary marriage. Thank you, Chair.
Thank you so much, Ms. Ross. Before I take a second round of questions, I note Member Marais. Is there any other member that would want to ask any additional questions on the briefing that we have received? Over to you, Member Marais.
Thank you very much, Chair. I would like to know if a man is in a customary marriage with 2 or 3 women, he then decides to marry a woman from another culture, and she wants to get married in a church or before a magistrate in terms of community of property. And if this man now dies, does the customary marriages get precedence over the person who married community of property, or does the woman who married community of property get half of his estate and the other half must be divided between all the other women he has? I would like to know this because it can become very tricky, because community of property is totally different from a customary law. There, the woman has half of the man's estate, whether it is movable property, immovable, or whatever, which personal effects, and when the man dies, she has the right to make out her own will, and everything that she then gets out of the marriage, she can leave to her children, and the other wives and their children get nothing. Does the law address this, sir?
Thank you so much, Member Marais. Over to Ms. Ross.
Chair, not in this bill, because as I've indicated, this bill only gives effect to the decision of the of the Constitutional Court in these two matters, the Gumede and Ramohovi. But what Honorable Mare is alluding to, a person who is already a party to a customary marriage, or rather, who is already a party to a monogamous civil marriage, can not, because it boils down to a question: does a subsequent customary marriage invalidate a previous customary marriage? No. Does a customary marriage invalidate a later civil marriage? And if you bring in the dimension of a will, it is a choice of any person to do as they, to distribute their assets the way they please under a will. But like Honorable Mare has indicated, this is a very tricky situation because it's a question of which marriage invalidates which marriage. But a person who is already married in terms of customary law can proceed and marry in terms of civil law. That is not the law, because the law protects proprietary consequences, the proprietary rights of the parties to the marriage, to the spouses. Thank you, Chair.
Chair, with your permission, can I raise something quickly, please?
You may go ahead.
Yes, Chair, thank you. By way of an introduction, my colleague, Ms. Ross, has introduced me to the committee. And just for completion's sake, I would like to introduce myself. My name is Makubela, and my surname is Mukuduvete. Chair, in addition to what my colleague Ms. Ross has just addressed the committee on, I believe what come to my mind in relation to the question that is raised by Honorable Mare, I think in addition to what Ms. Ross has said, the answer lies in Section 7, Subsection 6 of the existing Customary Marriages Act. If I may read it out, Chair, it reads as follows: a husband in a marriage, in a customary marriage, who wishes to enter into a further customary marriage with another woman after the commencement of this act must make an application to the court to approve a written contract which will regulate the future matrimonial property system of his marriages. I believe, in short, that will be a short answer to Honorable Mare. And as Ms. Ross has mentioned, the bill that we are intending to promote is essentially to deal with the issues that have been raised in the Ramohovi judgment and the Gumede judgment. And it does not deal with other aspects which are dealt with in the act itself, especially the question that has been raised by Honorable Mare. That will be my addition to Ms. Ross' response. Thank you, Chair.
Thank you so much, Mr. Mokulubete and Ms. Ross. Members, if there is no further follow-up questions or points of clarity? I see Member Marais. Over to you, sir.
Thank you, Chair. Sir, the question was answered in a way that doesn't solve my problem. In both cases, the learned legal advisors told us if a man is already in a customary marriage and then he marries another woman also by customary law. That's what I asked. I said a man who's in a civil union, community of property, a black man marries a colored or white woman who don't belong to his culture, and she's not going to marry a cultural marriage. She wants to go to a magistrate or to a church and she gets married there. So this one woman now has rights to half of this man's estate because they married community of property. And what about his other 4 wives? Must they now divide the other half between them? Is that what this will ultimately lead to? How is this addressed?
Thank you for the clarity, Member Marais. Mr. Makulabete, would you want to answer that question? But before you answer, members, by show of hand, if you have any further additional questions, you can raise your hand. In the meantime, if no hands are raised, we will then accordingly excuse the department after the answer. Over to the department.
Okay, thank you, Chair. I believe what Honorable Marais is raising is exactly what I have just raised, to say that the contract that must be in writing to regulate the future property regime should be authorized by the court, and that will be a way of making it clearer as to how the property regime in the various or in the polygamous marriages is going to apply. Chair, I cannot take it any further than to say that the simplification of this issue will be in the form of a written contract, which must be approved by the court, where the court will be able to determine if the contract will be proper to be able to cover every spouse in this marriage in terms of their properties. Thank you, Chair.
Thank you so much. Member Marais, your hand still raised. Is it on the same matter? Oh, there we go. Members, seeing that no further hands are raised, I see no further hands are raised. To Ms. Ross and Mr. Mokulabete, thank you so much for your attendance and for availing yourself at this time to brief the Standing Committee on Community Safety, Cultural Affairs and Sport with regard to the bill. On that note, you are now excused, but I would want to also indicate that we may call upon you in terms of our public participation process, if and when that takes place and how it will take place, but we will then be in contact. But thank you so much for availing yourself after business hours. You are now excused.
Thank you very much, Chair. It's much appreciated.
Thank you so much. Members, in order for us to conclude our business for today, and similar to yesterday, I'll allow our procedural officers to give input in this regard. But first, if I can hear from any member in terms of any resolution stemming from the briefing. I note, yes, Member Marais.
Chair, I think that we've got to think very, very deep about this matter, because the legal people couldn't answer my question. They now left it up to the magistrate to decide. Magistrates cannot make law. Only the Constitutional Court. Magistrate can't make a law and say, now you get so much and you get so much, if the law didn't stipulate that. I think we've got to our own legal department's got to examine this and ask. We try to do justice to all women here. They must have equal rights, and the women, the second and the third and the fourth wife, all now have a claim to this man estate, whether they married him before the bill was passed or after 1994. But we left out people that marry across cultural lines. You got a different culture and who got married to this man in terms of a culture that has different rules. The colored and the whites and even other black groups, they all have different cultural laws. Our culture says you get married community of property or you get married by anti-nuptial contract. And now they marry. Now, does it mean if I'm married in community of property with a woman and I'm married with 3 other black women in terms of cultural law, do I, if I'm a colored woman or a white woman, get half and the other half must be shared by the other women? So how does this improve the rights of women in terms of equality? This committee is going to throw this back at the legal department and say, really, the whole purpose of this act only refers to women of one culture. It doesn't refer to women of other cultures.
Thank you so much, Member Marais. We are in the initial stages. After the briefing, there's a public participation process. There is then a negotiating mandate as well as a final mandate. Before I hand over to Permanent Delegate Sileko for input, I checked in with him in this regard regarding dates from the NCOP. But before he gives input, Mr. Maasdorp, in terms of any legality point of view, is there any comment from you, sir?
Thank you, Chair. Chair, there are 3 things which I am focusing on now. The first is that there is an existing recognition of Customary Marriages Act in place since 1998. That act, that very act, was considered, was interpreted, was applied by the Constitutional Court when that court was seized with the current cases which we are dealing with now. That act was deemed, when it was passed, as constitutionally valid. Period. Because of the application of that act, the court in Limpopo found that there are certain unfairness, impropriety that emanate from the application of that act, as a result of which certain spouses were discriminated against for whatever reason. We are now not dealing with that act. We are now dealing with a consequence of 2 constitutional court judgments which were necessitated in order to equalize the regime pertaining to marital consequences. This committee is seized with that bill now. This committee is seized to engage its mind to consider whether the consequences of those judgments can and should be properly infused in the already existing recognition of Customary Marriages Act. I assume that members, in dealing with an amendment bill, are and will be familiar with the Principal Act. I will assume that. So on your question, Chair, if I have any comments on this amendment bill, I have no questions because the substance of this amendment act is effectively articulating a constitutional court judgment pertaining to the marital regime before 1998 and the marital regime post 1998. And we as a committee are obliged to consider whether these consequential amendments, as the Constitution have found to be invalid, if these amendments properly reflect the judgment and the rationale, the legal decision of those two judgments. It's very straightforward. The substance of this bill is uncontroversial. The only matter that is pending, as Ms. Ross repeatedly mentioned, is the issue of definition. She has, in fact, in addition, assisted the committee by saying, notwithstanding the absence of those definitions, because there's a parallel process happening initiated by Home Affairs, notwithstanding that, this bill is in fact out of time already as we speak, because it was supposed to have been passed some time ago. We, therefore, are seized with a principal decision, namely, do these amendments effectively and properly and unambiguously give effect to the Constitutional Court judgments as was raised by the two colleagues. With that in mind, I have no question that they in fact do raise the issues that the court flagged for constitutionality, and they give effect to the rationale behind that Constitutional Court's judgment. From where I'm sitting, I can advise the committee, as I in fact am doing, that there should be no reservation to support the amendment of the Principal Act, which I am sure members have familiarized themselves, because this amendment is simply an attempt to infuse Constitutional Court judgment into an existing act. Thank you, Chair.
Thank you for your reply, Advocate. Truly, at this time of the night, it is enlightening. I do appreciate it. I've noted Member Marais and Member Bota's hand was up.
Chair?
Mr. Marsdorp, I can assure you I am a man who do my homework. The Constitutional Court can also err. That is why we had to go back to the Constitutional Court, or even after it ratified the original Act. Constitutional Court had to again look at an amendment to the Act. So if we're not going to discuss these issues, the Constitutional Court will be called on to amend this Act another 3 or 4 times. This is the question I'm raising. The purpose of the Act was to make sure that all women are equal. And all I want to know, are people of all cultures going to be treated, even in terms of this amendment, equal? And that is the point. It's not to say, I assume that Mr. Marais looked at the original Act. I haven't been born yesterday in politics. I'm asking a different question. I'm saying, is this amendment intended to protect customary marriages between the Nguni tribes or at the same time, other marriages of women not belonging to the Nguni? That's all I want to say, and with that I close whatever discussions I further have.
Thank you so much, Member Marais. We won't be opening up that discussion now, but let me just, I note Member Botha.
Thank you very much, Chair, and I also welcome the input from Mr. Marsdorp, because he enlightened me also. And I want to say that we have to get to the constituents where this bill or law would matter to. And that is the public hearings that we have to embark on. And I think, Chair, in terms of a next step, and maybe we should listen to our NCOP member also after this, in regard to what the timelines are in regard to this, and get the input from where it really bread and butter matters. Thanks, Chair.
Thank you so much, Member Botha. Before we hand over to the permanent delegate, Advocate Maasdorp, I see your hand is raised.
Yes, Chair. I hope I'm not preempting the permanent delegate now, but just to amplify on what Member Botha said. Yes, indeed, because that is the role that we play now, post the briefing, is that we have to almost popularize this amendment by engaging people out there who have a direct and legitimate interest in the consequences of this bill. So it seems, from where I'm sitting at least, that a public participation process will have to be, because we are very much aware that there are cultural groupings in this province. There may even be a spouse in this province who is married to someone in the Eastern Cape and now resides here for corporate or business reasons. So someone living here definitely will have a material and legitimate interest in the consequences and the substance of this bill. Once we have that round, and I'm sure that out there will probably be people who share the viewpoint and perspective of Member Marais. Once we have those submissions, we can certainly gather again and make a substantive submission to the NCOP to say that we support this bill, period, or we support this bill only insofar as it pertains to X, or we don't support this bill because it doesn't go far enough. So certainly Member Marais is correct to foresee eventualities, and hopefully those eventualities will be raised by people legitimately out there who may have an interest in the consequences. So I agree with Member Botha that a public participation process may be well advised and be a prudent exercise so that we can come up with our own on-the-ground submissions in order to guide our negotiating mandate.
Thank you so much. I can assure you on a Thursday evening, 7:30, we are all sitting on that side, sir. Thank you so much for your input. Permanent Delegate, Honorable Seleku.
Good evening again, the Honorable Chair. Like Mr. Maasdorp has said, that after a briefing, usually what happens is that the province will decide on how they are going to go about in terms of their public participation, so that when they have to take a decision in terms of their negotiating mandate and their final, then there will be, there will be inputs and they'll be more informed. But while you were still in this meeting, I had a call with a chairperson of which is Honorable Sheikh, in terms of the timeframes, or by when do we actually expect the province to give us a final negotiating mandate. And what she has shared with me was that what we are currently engaging now is to go to all provinces and then we do the briefing. And as soon as we, because of this COVID-19 pandemic, as soon as we have exact timeframes, then it will be communicated with the province. And should there be a need from the province for an extension in terms of participation, then that request, she believes, would not be denied, because what is important is that public participation is very much important, because there has been a court judgment stating that if you don't do thorough public participation, the bill might not be approved. Thank you very much. I hope it answers the questions that the members have. Thank you very much.
Thank you so much to our permanent delegate, Honorable Seleku. Members, any other comment from anyone? I'll now allow our procedural officers, senior or Wasi Matthews or Mr. Ben Daza to just once again brief us in terms of the way forward in the public participation process as discussed yesterday as one of the options that we could potentially explore.
Thank you, Chair. Ben Daza. It's a similar process as yesterday, Chairperson. The committee will have to decide its form of public participation, and obviously considering the pandemic. So it's up to the committee. It may want to decide to advertise, call for written submissions, and also call for oral submissions. It may call for visual hearings. It's not possible now these days to have an in-person meetings as you would like to do on situations like this. We have also, in terms of resources, allocated procedural officers with WhatsApp numbers where members of the public can also make submissions, oral submissions by means of voice note. So we will request the committee for now to decide on its public participation process, how it will conduct its public participation, in line with yesterday's meeting as well, Chair. Thank you.
Thank you so much, Mr. Daza. I note Honorable Mare, Member Seleku, and then Member Botha in that order.
Thank you, sir. Mr. Romeo Marsdorp, I salute you. Yes, you've come on board on this aspect, and I think you have a fuller understanding of what I actually was aiming at. Thanks for that. I want to come to the public participation process. If we are not going to give the public an executive analysis of what this amendment is about, then it will be, in most cases, like calling a labourer on a railway to come and present his opposition to a document drafted by Judge Kenridge or Advocate Kenridge. He wouldn't understand what it's all about. So, are we going to give a layman's explanation to the public before the time when we invite them to say this is what this amendment seeks to do, this is the original act which we are amending, and that it will affect you IBC? Then public participation will be meaningful. But you cannot expect the people to understand issues their minds have not been trained to understand. And I want to ask you that if this committee decides, or any committee, to go on a public participation exercise, that they are faced with a fully informed public and not just people. Thank you.
Member Seleku?
No, thank you very much. It's very interesting to be in this meeting, I must say. Chair, I think what is important, that what Member Botha has alluded to is that is the word of constituencies. And with all this COVID around us, and I am very, very much worried, and I don't know how we're going to go about it, because if this particular constituency that we want to actually go to, and that it will be affected by this particular amendment, is not, is not clued up, to the third, it's not clued up in terms, they are not computer savvy, they are not into WhatsApps, and they are not into these virtual meetings that we are having as members of parliament. And we really, really need for them to be part and parcel of public participation, because it actually deals with them directly. What other options can we look at so that we make sure that we get maximum public participation, and then it does not happen like what we do, previously in terms of the IDPs, that you go through a process of IDP and then you find 5 members, and then you say that the community has commented on the IDP. But if you look in terms of demographics, that particular ward has about 3,000 members, but only 5 came, and then you went ahead with the meeting, because what you have done, you have sent out notices, you have sent out SMSs, and you have done your part, but they did not adhere to your request or to your invitation. And those are the issues that we actually need to consider and make sure, if this matter is going to affect those, Umama, Usilegu, who's already in this particular marriage, polygamous marriage, and who has been discriminated for all these years, and now, it says, no, there is actually a remedy for you, should something happen within your marriage, you also have rights now. And how are we going to make sure that she's actually aware and she can actually participate, and she can actually know what is coming? That is just my concern. I'm battling with Chair. Thank you very much.
Thank you so much, Member Botha.
Thank you very much, Chair. I agree with both members, and I want to add, I want to say, in terms of when we embark on doing the advertisement to call for, to have your say, I want to concur with Member Marais that we do a half-pager or a one-pager, just summarizing in layman's terms what the amendments to the bill is, so that our communities or our constituents who will be most affected, so that they can understand. So that's the first one. So that needs to be part of the advert. And then in terms of the challenge that we have, that we cannot do in-person meetings. I want to say then, Chair, that we need to get the buy-in of our municipalities out there to assist, so that in regard to what Member Seleko has just said, so that our constituents out there can be supported, either to be able to be supported by the data to either send a WhatsApp or to send a mail, or when we decide to do the public hearings, to be able to do it with government data, if I can term it that way. In saying that, we cannot just do one public hearing. So I am proposing that we then also look at multiple virtual public hearings, and that together with the accepting submissions in a written form, either through a WhatsApp or through sending an email. Thank you, Chair.
Thank you so much, Member Botha. I see Member Marais and Member Seleko, your hand is still raised. But I see Member, I see Mr. Daza, your hand is raised, sir.
Yes, thank you, Chair. I think my input is in line with the issue that was raised by Member Marais and Member Botha. What we normally do for public hearings, we request the department, the national department, to also be present. That is also to assist the members of the public in order to understand what the bill is about. Sometimes they don't come, but I think you also requested them, and because we've indicated that you did that even on yesterday's meeting. So, but there's another option that I have that I didn't give the committee, which is a little bit trickier option. It is the committee can, on behalf of the province of the Western Cape, and say, we request the NCOP to postpone this process because of the pandemic, in order to do proper public consultation, because the people that are affected by this bill will not be able to make meaningful submissions to the committee. That's another option. But it's a tricky option because the NCOP needs about 5 provinces. If they agree, then the bill will go ahead and we might be left. So that's why I say it's a very tricky one. So it's up to the committee, but committees have indicated before, have requested, provinces have requested before to national, to NCOP, say, look, we cannot do proper public consultation. We request more time. But maybe because of the pandemic, it might be one of the options that the committee can also explore based on the inputs that I've seen now from members. Thank you, Chair.
Thank you so much, Mr. Daza, I see Member Botha. Your hand is raised.
Thank you, Chair, for noting me. In with regard to what Mr. Daza then just said to us now, maybe Chair, at your earliest convenience tomorrow, if you and our procedural officer can then start writing that letter to the NCOP requesting a postponement. Thank you.
I would also lean towards that. Thank you for that. Member Keiko, your hand is raised, and then Member Mare.
No, thanks, Chairperson. Mine also was to second what Member Botha has just raised. I think the guidance from Mr. Daza there to say we can be able to request for time. That's a very progressive step, because if you check what Mr. Masdorp was saying, that we have a responsibility to have a certain position here. But we cannot have a position but knowingly that there is a pandemic and our people will not have access to this public participation meaningfully. They will definitely participate, but they will not participate meaningfully as it is expected. And it will directly impact on them. We must check once it gets endorsed, then it might be amended in the future, but it will bear serious consequences for our people. So the postponement, the request for postponement might be a good idea. Thank you.
No, thank you so much for your input. I still see hands raised. Is it a different option, different proposal? Okay, no other hands are raised now. Members, on that note, I will be engaging our senior procedural officer together with Wasim Matthews, our procedural officer, first thing in the morning in this regard, and we will be in contact via email. I trust that you find that in order.
In order with me,
in order, Chair.
Then on that note, thank you so much for your attendance here. It is now almost 7:45. It's been a very long day for many. Our permanent delegate, Honorable Seleko, thank you for being here. Advocate Master, your input is valuable. Thank you, sir. Our procedural officers, Mr. Ben Daza and Wasim Matthews, and all those that were participating, thank you so much, and may you have a good evening. This meeting is now adjourned.
Thank you, Chair.